Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
All right, so I won't go back to our humanoid robot, but I will talk about a few new developments that have occurred over the last week, and that is that the first one is that the federal government under the Trump administration is doubling down on its quest to eliminate DE&I in the workplace. And what they're doing now is they are targeting government contractors and grant recipients that have discriminatory, quote unquote, discriminatory diversity programs. And what they're trying to do is use the federal False Claims Act enforcement through the Justice Department, and they're urging workers to blow the whistle on their employers. Again, if their employer is a federal contractor or their employer receives federal grant money, they're using the False Claims Act to encourage employees of those companies to blow the whistle if their company is maintaining a quote unquote illegal diversity, equity, and inclusion program. So just another hurdle, another risk out there for employers. I've always said it on this program that DE&I can be done, but you have to be very, very careful in how you do it. You need to make sure that you are not using it as a mechanism to skirt the employment laws. Again, Title VII says you need to make decisions without regard to protected categories. And if your DE&I program uses protected categories in the decision making, it could run afoul of Title VII. So you just need to be careful on how you're doing things out there.
Yeah, that's an interesting strategy by the administration. But I think what I'd like to hear you follow that with, Burt, if you can talk about, is what's going on with the EEOC.
Well, the EEOC is. Are you getting at something in particular, Phil?
No, well, I just know that there's some suggested budget cuts. Is it going away? I'm hearing all kinds of discussions. People are asking me about it. And I don't know if you had anything to cover on that, or you could share with us.
Well, I want to make sure we're talking about the right agency here, because I think the one that you're probably getting at is the OFCCP.
Oh, yes, I'm sorry. Yes, right. I'm sorry. Yeah. My bad. Yep.
You threw me for a little bit of a loop there. So yeah, the OFCCP also in hot news right now. Lawyer on the clock. May 30th, just last week, the Department of Labor released its budget justification for fiscal year 2026. And in that budget justification, the Department of Labor has proposed to absolutely and completely eliminate the OFCCP. And of course, that's the Office of Federal Contract Compliance Programs. So that segues nicely from our last topic. That agency had been tasked with enforcing anti-discrimination compliance and affirmative action program obligations in federal contracting, but some recent executive orders under the Trump administration severely limited the OFCCP's authority. In the budget justification, the Department of Labor indicated that it would transfer OFCCP's enforcement of the Vietnam-era Veterans Readjustment Assistance Act, or VERA, to the Veterans Employment and Training Service, or to the VETS agency, and enforcement of Section 503 of the Rehabilitation Act of 1973 would be transferred to the EEOC. So the OFCCP, the Department of Labor, is talking about completely eliminating it. It did not seek any federal budget funding for OFCCP, but it did request a $7 million increase for the VETS program. And so, again, just keep in mind that this proposal comes after President Trump's executive order 14173, which revoked executive order 11246. That executive order had prohibited employment discrimination by federal contractors and mandated affirmative action programs for women and minorities. So again, another thing to keep your eye on, OFCCP may be going away in its entirety.
So is this, as you think about that, is this the, more bringing to conclusion more of the end of affirmative action plans as we knew them, obviously with the exception of vets and disabilities. Because it was, some employers are like, well, we're going to wait and see what happens after the, 90 days or 180 days, whatever it was. And I guess I see this as more affirming that it's probably not coming back, at least under this administration.
Yeah, I think that's correct. I think that
Yeah.
it is not coming back under this administration.
Yeah. Okay.
Yep.
What else you got
Now-
there, Mr. Non-AI lawyer on the clock here?
So the another one that I wanted to cover, Phil, and I think I'm hopeful that all of our listeners can get behind this one. Just Monday of this week, the Department of Labor announced the launch of its opinion letter program that provides employers and workers with official interpretation of federal labor laws or federal wage and hour laws. The program's goal is really to promote clarity, consistency, and transparency in the application of the federal labor standards. We've sort of seen the pendulum move back and forth on this issue. The documents will be published by 5 enforcement agencies within the Department of Labor, so Wage and Hour, OSHA, the Employee Benefits Security Administration, VETS, and the Mine Safety and Health Administration. And when I say the pendulum has swung on this, is I think from administration to administration, it used to be that all administrations, the Department of Labor would issue opinion letters. And those are letters where anyone could submit a request for an opinion letter to the Department of Labor, although most of those are requested by employers. And those letters seek clarity on situations that are not necessarily addressed in the statutes or regulations. DOL opinion letters are published and they allow all people to benefit from the guidance provided in those letters, and it sort of gives you the Department of Labor's position on an issue so that you can make sure your practices are consistent with the Department of Labor's interpretation of the issue. The pendulum has swung in recent years where certain administrations have eliminated the use of opinion letters, tending not to give any advice to employers or anyone else out there on what the law might be, and play more of a gotcha with employers when employers do things wrong. So I am hoping that no matter how you feel about this current administration or other administrations, I'm hoping that most people can get behind the idea that the Department of Labor issuing opinion letters, allowing employers and others to seek guidance from the Department of Labor so that they can conform their practices to what the department believes is the law. I think that's a good thing.
I am with you on that. I'm aligned with that 100%.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.